Ms. Blatt, what about Justice Sotomayor's dating hypothetical? The discrimination, like, oh, we're not gonna match black people and white people, et cetera. What about that? Is that given 230 shields?
Absolutely not, because any disparate treatment claim or race discrimination is saying you're treating people different regardless of the content. So if let me use it like with an advertising, like, I don't know, whether I'm a woman of 10 or, I mean, it was a bad example, a woman of 30 or whatever, and whether I live somewhere, it really doesn't matter in terms of the law that's prohibiting discrimination. The law is indifferent to what the content is. It's just very unhappy about any kind of status-based distinction. So we think, and the harm that would flow is not the third-party information, it's the website's conduct, whether you want to call it speech or conduct, that's based on status.
But what about the dating profile? I mean, isn't that part of the content? Isn't that part of the third-party information?
Sure, and it's just, you could put it a bunch of different ways. You could say even before the profiles go up, there's a complete harm, or even if the profiles go up, it doesn't matter. We would distinguish between the way dating sites work, which don't work based on status, but based on criteria that's uploaded, and those are, you're matching with somebody else. The website is not saying you should only date a white person.
Okay, then what about news? What about an algorithm that says, you are a white person, you're only going to be interested in news about white people, and I'll screen out anything that is a story featuring racial justice issues?
Yeah, again, anything based on status, because the harm is complete independent of the information. But if a website wants to say we're going to celebrate Black History Month, no, a white person or a black person is not going to be able to complain and say, well, I didn't get enough White History Month on your website. Those are claims that are core within treating them as publishing of the information.
Yeah, but I guess don't you think you're just fighting on liability? I mean, it seems to me that you're kind of going back to liability because all of those are choices that are made independently, right? I mean, we've been talking about the distinction between, or the lack of distinction in your view, between the content itself and the website's choice of how to publish it. I guess I don't see why. So here's 230 purposes.
Here's our test, and it's the test the Fourth Circuit recently took in Henderson, and it's the test the Ninth Circuit took. Let me give you an example that I think may help with the ad revenue sharing. So this was an allegation that YouTube was giving money to ISIS. Now this was in connection with third-party videos, third-party information, but the court said no, that is not within Section 230 because that's independent of the information, that's giving money to ISIS. That kind of, whatever you think about its validity under the statute, you're not treating them as a publisher, you're treating them as a financer. And it's just, and that's the test of the Fourth Circuit too. The Fourth Circuit is looking, in that case, it was about, all kinds of things were happening with third-party information, and they were trying to tease out, is it the credit report? Did they contribute to the credit report? Was it based on the website's failure to notify the employee? And what the Fourth Circuit said is the exact same thing we said, and it's the exact same thing the plaintiff has said on 4 pages of its brief, or 4 times in its brief, that you're looking for the harm. What is the harm caused? And this case is the perfect example. The plaintiffs suffered a terrible fate, and their argument is it's because people were radicalized by ISIS. And if you start with the concession that the dissemination of those ISIS videos and a claim based on that is barred, the question is what additional comes from the way it was organized? The government just says, I don't know, let some state figure it out. That's not very helpful to internets that have to work on a national level and are posting and sorting and organizing billions upon billions upon billions of pieces of information.
So just to clarify, this is my last point, you're happy with the Henderson test, the Fourth Circuit test?
Yes, I would say Henderson is like 96% correct. I got a little lost when they were going down the common law and publication, but the result was great. I just thought they got a little weird on the publication. But yeah, no, their test is correct, and it's also the Ninth Circuit's test on the ISIS revenue. It's the exact same test we quote in our brief, and it's the exact same test petitioner did. And what that harm test is doing, if I could just explain it, because it sounds kind of shorthand, but if you take which I'm not sure Justice Jackson agrees with, but if you take the underlying notion that this bars treatment as a publisher, and you're saying, well, can they get around it by the way they're pleading it? You're just looking to the harm. So you're saying you can't really say that's negligence or intentional affliction because the harm is coming from the publishing of the defamatory content. And so what I think all these cases where the courts are correctly saying 230 does not apply to the claim is they're isolating the harm and saying that's independent of the third-party information. It's either based on the website's own speech or its website's own conduct that's independent of the harm flowing from the third-party information.